policy that has been made around this. So if we all agree, can we start formally? Ekta, should we start?
Yeah.
Yes, ma'am.
So just to let you know that Ekta and Rustam would be holding the forte today. So over to you, both of you.
Cool.
Hello, everyone, and welcome to today's roundtable discussion on Fresh Start process. One of the methods for resolving the insolvency of individual is the Fresh Start process. This is applicable for individuals and partnership firms. Um, as you all know, these provisions, though have not been notified, they have claimed to give the debtors with comparatively smaller debts chance to discharge their debts and start afresh without any liabilities. I would now welcome the panelists. We have Dr. John Tribe, who is a senior lecturer of law at University of Liverpool. Sir's research interests are insolvency law, bankruptcy, history, and equity and trust. I would welcome Dr. Renuka Sane, who is an associate professor at the National Institute of Public Finance and Policy. Her research interests are household finance, pension, consumer protection and finance. I would also like to tell you all that ma'am's recent publication was on designing a personal insolvency regime baseline framework, which was published in the year 2020 in the IBBI yearbook. I also welcome Professor H.S. Shailendra. Sir is a professor at Institute of Rural Management, IRMA, Anand. Sir's interest area are also rural development, poverty, rural livelihood, microfinance, and rural finance. Uh, this roundtable conference aims to explore the contours of the Fresh Start process and the concerns operationalizing the extent of the provisions. Um, I now hand over the podium to Neeti ma'am. Yeah.
Yeah. So just to let all the audience know today that we did one roundtable last year, and we had a lot of learnings from that. And this year we thought new rules have come, new discussions are happening around Fresh Start process. So we thought it'd be good to visit back. And I'm happy to also share that Professor Shailendra and Professor Renuka were part of the earlier panels. So it'll be good to see to get their inputs as to how the law has sort of developed. Just a quick, let me put off my camera. The internet is a little slow here. So just to give you a little background about ISEA. ISEA has been established by the Ministry of Corporate Affairs as a think tank, capacity building, and service delivery institute that curates repository of data and knowledge for policymakers. It is the sole institute in the country today that has been authorized by the IBBI to run its flagship program, GIP. And I'm happy to share with you that the second batch of GIP is attending this discussion, and the third batch is already on its way. We have announced the admissions for the third batch. Now, as a part of the core structure for GIP, we organize series of roundtables to bring together diverse group of practitioners, academics, and policymakers, and we encourage deliberations on some key issues pertaining to insolvency and related areas. Now, in Fresh Start is one area where one might say that it's not very contemporary in India because uh, not a lot of debate right now. Pre-pack has really stolen the center stage of discussion on insolvency in India. We are having one roundtable next week on pre-packs. But I feel that one of the main concerns in India today, if we see from insolvency space, is individual insolvency, and a lot has been discussed, but a lot still needs to be deliberated. Now, instead of restructuring the debt of debtor, what Fresh Start process does is it discharges the debtor from qualifying debts if the debtor meets certain laid down eligibility criteria. It is distinct from other insolvency processes like reorganization or restructuring. And this distinction has been consciously created by the policymakers for certain debtors who have low income and low asset value. And hence, what the Fresh Start process does is it makes available for debtors, it's made available for debtors where the chances of recovery may be so low that cost of resolving insolvency is otherwise only an additional burden not only to the debtors, but also to the creditors and state. So I will not deep dive into it. We have experts with us today, and it'd be interesting to see how issues are flagged. And I'm really happy that Professor Tribe could join this discussion, because there are certain policy concerns that we have with Restart. Like, I mean, in simplistically put, is seen as a loan waiver, a private loan waiver by state. So where does the law gather its basis from? Where does the law gather its strength from? Professor Tribe, I'll be happy to have your inputs on that. Does equity support it to allow a state to have laws that could really seize a private loan waiver? And interestingly, and very fortunately, we have two experts, Dr. Sane and Professor Shalendra. I think they have been uh, with us, with Indian ecosystem, insolvency ecosystem, and fresh start since the beginning. And I'll be very happy to hear if you had some change of views, a change of minds over the period as the law has the policy has panned out. So, thank you, Ekta. With this remark, I would like to, um, welcome all the panelists, our esteemed panelists, and especially to our students who have taken so much of interest. Welcome all, and let's get the deliberations on. Over to you, Ekta.
Uh, Hi all. We have brought 5 themes to be discussed for this roundtable. So the first agenda is the social cause of Fresh Start and the impact of microfinance institution. I would like to know, Renuka ma'am, if would you like to, we'd like to start with you and would like to know your views on it.
Yeah, sure. So how would you like me to do this?
Ma'am, however you're comfortable with at the moment.
So is it hello?
Yes,
Hello,
yes.
can you hear me? Hello?
Yes, ma'am, we can hear you. Yes, Renuka, ma'am, we can hear you.
Yeah, okay. So I thought students were presenting today. So can you just explain the format for the day a little bit more before we start?
Yes. So sorry, Renuka, we took liberty to change the format, and my apologies that we didn't brief you on that. So we will be jumping right into the agenda, and we'll discuss that. Ekta, would you like to build up?
Do, do, do you want some just sort of general observations on Fresh Start, and as in, or, the idea that one might extend a mechanism of this type to debtors and why that's important, that kind of thing?
Yeah, so I mean, I'm happy to chat about that or about the impact or the concerns of the microfinance industry regarding the Fresh Start. So, but I'm sorry,
Yeah.
uh,
So let me.
I'm a little
My
confused about what the
so,
agenda is then, because my
so
understanding is a little different. My apologies for that.
no. So let me just sort of reconcile this confusion, so that we can have a good deliberation. So what we had a shift from the last year, but what we can do right now is we jump straight into the agenda, and maybe then what between me, Ekta, and Rustam, we'll take one agenda each. We'll sort of give a background, and then we'll invite your comments on that. So just to sort of look at the first agenda, all of you. So the first agenda is social cause for Fresh Start and its impact on microfinance. And I remember reading Urjit Patel, which is also in the document. He said, even if the loan waiver is accommodated with the budgetary provision, it will force cutbacks on other heads of expenditure. Experience has shown that most vulnerable category of expenditure in turn and will entail deterioration of the quality of expenditure, among other things, leading to adverse implication for the productivity as an asset forming investment. So, I mean, just for knowledge of Mr. Trivia, Mr. Urjit Patel, he has been with the RBI at a very senior position, and he expressed his concerns about this policy that we are bringing in on Fresh Start. And what we see is that it can have a very deteriorating impact on the economy. So, uh, you know, in previously, government did have Rin Maaf Yojana. Rin Maaf Yojana basically is sort of bailout for poor people, and they will announce loan waivers. So just a quick question on that, Renuka. You have done a lot of ground research. What do you think about, the, the Fresh Start having the social cause, or rather say social cost on microfinancing institutions?
So
What is your take on that?
yeah, thanks, Niti, and thanks for clarifying. What we are planning to do today. So I think to answer your question, one must make a fundamental difference. There is a fundamental difference between what we see as Fresh Start and what we see as loan waivers that have been implemented in India so far. So one of the big difference is that if and when Fresh Start is constituted, this is known before the loan is given out, and there are processes through which eligibility for Fresh Start is determined. And number three, the microfinance industry will also price the possibility of a fresh start in their loan. It is also likely to change the decisions that they make on evaluating credit risk and giving out further loans. So I think that one needs to distinguish between a fresh start as a transition and fresh start in equilibrium. So, and much of the discussion in India has gotten stuck on this fresh start in transition, which is that tomorrow, if we bring in a process of fresh start, what happens to all the loans that have already been given out that were not priced, keeping in view that something like a debt waiver, systematic debt waiver may actually happen. So one thing is that we do need to distinguish between the equilibrium and the transition. And the second thing we need to distinguish between Fresh Start and loan waivers is the fact that Fresh Start is more systematic, whereas loan waivers were, as you all know, related more to political considerations as well. And they seem to have no impact on the credit history of the people who availed of the Fresh Start or who were not able to pay loans. Avail the loan waivers, sorry. In the case of the Fresh Start, we will be maintaining records, and the trade-off between taking a debt waiver now and having potentially slightly more expensive credit later is a decision that we are now forcing on to the individual. Whereas earlier, this decision was not with the individual, it was with the government, who decided to just announce fresh starts as they deem fit. And hence, the question of moral hazard became extremely imminent because, it was just in my interest then to wait it out before the government announced a loan waiver because I had nothing to lose. Whereas in the case of the Fresh Start, once this is systematic and once the individual is making a decision on whether to take the debt waiver and suffer the consequences in terms of potentially higher credit, potentially more expensive credit later, then I think that we are shifting the burden and the design of the moral hazard really by making this more systematic, more an individual's decision. And of course, we will see some changes in the way microfinance industry is structured and pricing its loans going forward. But we do have to worry about the transition because all the loans that have been given out already have been priced without thinking about the potential debt waivers that might be coming. So that is a distinction that we should make and we should worry about because we should not be dumping this on the microfinance industry and saying just deal with it because we've made a sudden announcement. So I hope this answers some of your questions, and I'm happy to talk about this further.
Yeah, thank you, Renuka. Professor Shailendra, what are your thoughts on this? You think this fundamentally different? Uh, if you look at the impact of what Fresh Start does, are we not reaching at the same outcome? So can we really say it's a fundamentally different process?
Yeah, yeah. Let me, again highlight my views on this Fresh Start process and the microfinance institutions. Right. Of course, some of the points Dr. Renuka made are relevant, particularly with regard to this microfinance sector. In a sense, microfinance sector is now totally wary of this fresh start process. They have a variety of concerns. They possibly think that this fresh start process will come in a big way and it will impact them negatively. Because, of course, though microfinance institutions have not got the benefit, in a sense, a benefit of any of the government loan waivers. All loan waivers have been for the other formal institutions like the commercial banks, regional rural banks, and the cooperative. Microfinance institutions, including self-help groups, which are again linked to the formal banks, they have not come under any of these loan waivers, right? So, but they did feel the pinch of loan waivers, because when loan waivers are happening elsewhere, even the members of microfinance institutions also expect governments to, in a sense, give the benefit of loan waivers to them. Many state governments did announce, but they withdrew later on. So therefore, with regard to loan waivers, microfinance institutions really have faced a lot of challenges, though they did not directly come under the purview. But at the same time, of course, they also suffered during demonetization. When government imposed demonetization, again, it was the microfinance institutions, because they deal with a lot of cash. Unlike formal institutions which deal with checks and the internet-based banking, etc., microfinance institutions deal with cash. Demonetization again had a very debilitating impact on them. So they came out of that. So now, of course, this whole issue of fresh start process, right? And they feel that, and that too because fresh start process is applicable to unsecured loans largely, right? Rather, it is applicable only to unsecured loans. So in a sense, microfinance loans are, of course, that is a debatable issue whether microfinance loans are fully secured or unsecured, but they feel that the whole burden of this, or to a significant extent, will be felt by them. So therefore, they are wary of it. Of course, microfinance institution to a significant extent cover the type of borrowers, the debtors that are visualized under fresh start process, in terms of the asset, in terms of the income, right, in terms of the debt size. So all these borrowers to a significant extent qualify. So microfinance institution therefore think that a significant proportion of their debtors will come under fresh start process, and all of them possibly, or most of them, will seek fresh start process because government is going to announce. People may perceive it as another kind of a loan waiver that has been now made applicable to microfinance sector, unlike in the past. So that will possibly will create a lot of difficulties. So therefore, they are wary of it, and it is likely that microfinance institutions are going to re-strategize their security policy, collateral policy, because apparently microfinance institutions are supposed to lend without collateral, right? And fresh start process is applicable for unsecured loans, right? So they will try and bring in hypothecation so that all loans become ineligible. That is my kind of a fear, right? Because once you say that these are secured loans, even if not by collateral, physical collateral, but you hypothecate their assets. It may be crop, it may be a cow, it may be livestock or any other asset. You hypothecate, it becomes a secured loan. Irrespective of the size, they come out of the fresh start process. That strategy they are likely to adopt. That is my fear. So, but given the intention of fresh start process, right? If that happens, right, by the formal lenders, including microfinance institution, that will defeat the whole purpose of fresh start process. Though it is applicable to informal loans also. Informal sector loans like money lenders, etc., also come under the purview. But in my understanding, based on my own experience, informal sector will not somehow come under, they will escape from this. They will evade from this. Both the borrowers, that is the debtor, and the creditors will not like to, even if there is some kind of a benefit, would not like to so easily come under this purview, because money lenders or debtors, they on their own will not apply for this. Right now, what happened recently in Karnataka when government announced a general moratorium on informal loans. 2 years back, they passed a law. All money lenders went to court and got a stay order. Right, that is one example. In Kerala, what happened? People did not come forward to report their informal loans. Right. So therefore, fresh start process, in my view, in some way, though it is applicable to informal sector, so informal sector will find its own way, both from the side of the borrowers and from the side of the creditors, so that they don't come under the purview. So in a sense, theoretically, it would leave this whole thing in a limbo. That's my this thing. Fresh start process will be there. It will be there as a provision under the IBB Act, but operationally it will face a lot of difficulties. So therefore, apart from these sectoral issues, even the criteria that have been prescribed by the fresh start process chapter are so restrictive, that it would render it inoperable. It will not work. So those are my sort of take on including microfinance institution, the working of fresh start process.
Right, sir. Renuka ma'am, do you want to add something to it?
No, I agree. I agree with what has been said. I also want to add one more point, which is so. I mean, if I just had to summarize, what we are saying is that on paper it is a good thing, but when it comes to implementation, it's going to be difficult because the microfinance industry will try and evade it through hypothecation. I think that's a very valid point. And the informal sector, even though technically may be covered, in reality it's very difficult, as we all know, to bring the informal sector under any particular law. My other worry with the fresh start is that it might drive, so debt, so, and this is a general question for all of us to ponder. Debt waivers work very well in a situation where finance is completely formal. So whereas in an economy where a large amount of finance is still informal, and the informal sector cannot be brought into a formal mechanism, are processes like these going to drive people to take more informal loans? Are processes like this going to drive people to take more secured, or lenders to only give more secured loans? That's something that is worth pondering. And I want to step back a little and say, why is this happening? Perhaps there is something peculiar about the nature of the microfinance industry and the cost of capital to the industry itself, and the provisioning norms for the NBFCs, such that if debt waivers to become a part of this, then what does it imply for the capital requirements of NBFCs that make it so difficult, or for NBFCs to deal with this, or that is making these NBFC MFIs get extremely worried about potential debt waiver schemes. So I think that there is, of course, the consumer side of it, and how the NBFCs will react to debt waivers, or what will happen to consumers who may then go to the informal sector. But on the other hand, we also need to think about what it does to the balance sheets of the NBFCs, and what is it about the current capital regulations that makes it extremely difficult to have a process like a fresh start for these two things to balance out. So, going forward, I think we do need to think more carefully about both these things and understand what is the fear from a capital perspective that is driving the NBFCs to do whatever it is that they are doing.
Right, absolutely. Like you mentioned, that although there is a fundamental difference between the loan waiver and the fresh start process, but the larger implication is that these microfinance institutions will not only face the brunt of it initially, but what impact will it have on the lending behavior? Like Shailendra sir also mentioned that, changing unsecured loans to secured in some form or the other. So I would now like to hear from Professor John, that the DRO model has been implemented in UK for quite some time now. So have you seen any significant changes in the lending behavior of the credit institutions because of it?
Hi, yeah. So I should preface my comments first by saying that I'm quite debtor friendly. So my perspectives in my writing and viewpoints generally come at these questions from a perspective that tries to help debtors as opposed to creditors. So in that sense, broadly speaking, I'd say that the kind of brunt, bearing the brunt point that you've just made around creditor behaviour, and also Professor Shailendra's points around sort of whether or not there could be systemic problems with the system, with the lack of engagement because of the ramifications on various creditors, and whether or not that sort of stymies the whole process that you're trying to undertake. For me, important questions, definitely, but I kind of think generally that creditors, they're engaged in profit wealth maximization by charging interest and return of capital sums that, they've entered a game, they know what they're doing. If they're going to take loss in due course, they're much better protected with deeper pockets generally to protect themselves. So, and an example of that has happened recently with reforms that have been mooted for our DROs. So we've just had a package of reform proposals to perfect debt relief orders here, and one of the measures has been to increase the amount of available surplus income that a debtor can keep. So at the moment it's £50. So after they've paid back, pursuant to a debt relief order, various sums to their creditors, they would have £50 left that they could buy a cinema ticket with or whatever. There's a proposal to increase that to 100. So that's not that much really in the grand scheme of things. Creditors have been really vociferous, really critical of that increase. And we're talking about a very minute sum, so they're trying to squeeze out the creditors as much as possible from these debtors. And this takes us to your agenda point, and the main reflection I had on your agenda point one with you say in the second sentence, that there's this, some find it as opening a Pandora's box resulting in intentional defaults. And then later on, it's the sort of penultimate paragraph. You've got a section about, and indeed the panelists have just spoken about, ethical hazards, moral hazards, and borrowers defaulting strategically in their behaviour. There was some research that was undertaken for the Insolvency Service here in 2005 that looked at when individuals debtors engage with insolvency processes, and at that time, 2005, so 4 years before DRO was introduced. And what that research showed, and it was empirical research that sent out questionnaires to 10,000 debtors, and it had a fairly good response rate. And that showed the vast majority of those debtors did not make strategic decisions to misuse a process to avoid their credit obligations. It was the fact, and I imagine this is why you're doing this with DROs or your equivalent Fresh Start, is because those debtors simply needed the pressure valve release mechanism of an insolvency procedure to go through, because they were totally at sea with their ability to function normally. So in terms of a balance between creditors and their participation in the system and debtors on the other hand, I definitely think the extension of a Fresh Start in your language or DRO in our language is imperative. But I totally understand the panelists' points and agree with them that if you've got a kind of transition period where you've got extant loans that have already been made, and you've got a strong credit community who are lobbying that this shouldn't affect us, that you're going to have to deal carefully with the retrospective effects of how you introduce this. So to summarize, in answer to your question about have you seen any changes in creditor behavior, no, because they just retarget their credit activity towards other targets. What we have seen though with DROs, in terms of the consequence of their introduction, is a massive uptake in them. So that shows you that there's the demand, and of course with the demand and use then comes the rehabilitation, Fresh Start, recovery that is the policy aim of the device. So so there's some brief reflections.
Absolutely, and I think these deliberations need to be made in order to ensure that this law is just not on paper, it's actually practiced on the ground. And
Ask
sorry, Renuka ma'am, I cut you short. Yeah.
Sorry, I wanted to ask Professor Tribe a question, which is that, when the DRO came in the UK, what kind of a division were you seeing in your market between formal lenders and informal lenders? So was there a substantial part of the economy that was still relying on informal lenders, or was it that everybody came under the purview of the DRO and formal lending, as you would call it? Because you see the structure of the market that we are facing here, because three-quarters of the market is not under any law, it changes some of the dynamics in terms of debtor behavior. So I completely agree with you, and I'm sympathetic to the need of a fresh start kind of a process from the perspective of a debtor. And in fact, over the last few months in the pandemic, we have seen a lot of stories in newspapers about personal loan defaults and how various companies are engaging in poor collection tactics that are detrimental to the debtors. So all of this is a reality, no question. But there is this issue of a structural problem in the way the Indian market is there today. And I was wondering if you could give us a little bit of a history, or how did the UK deal with this tension between the formal and the informal sector because of a process such as a fresh start?
So in broad terms, the majority users of both we tend to call debt relief orders here, we call DROs, we call them bankruptcy light, so LITE. So the idea that basically it's the same as bankruptcy, but there are two principal differences. One, the name, and that's important because of stigma and the idea of debtor engagement. That's why we've seen a massive uptake in DROs and a massive reduction in bankruptcy, because of the sort of terms of art that are used, which encourage debtors to participate. The other major point and sort of reflection on the DRO's qualities are its threshold levels. So, for example, that £50 I mentioned earlier, and the lower end cap on the amount of indebtedness. So, and that's currently £20,000. So, in English and Welsh law terms, DROs are used by, like your Fresh Start is envisaged in, where you've used in your document the low income, no assets, low income phrase. It is definitely targeted at those groups, and those groups of debtors here, indeed bankruptcy debtors as well, the vast majority would be using formal credit. So you're right to point out, I think, and it is a key difference perhaps between how these procedures are deployed here in India, this point about where the credit comes from. So in English and Welsh law, we wouldn't have much informal lending, and if we did, recovery mechanisms would be a lot different to these approaches, in the sense of sort of darker side of credit. So but then the use of DROs, I suppose, going back to Rostam's point as well, how's that changed creditor behaviour? It hasn't generally, in that there's this, a bit like limited liability companies, there's always this general accepted use that you're going to get some amount of failure. And your point earlier about how do we factor this in our lending decision, our interest charges, etc., is just the new metric that they've started to use to cope with the upsurge in DROs.
Okay. Yeah. Can I make a observation?
Sure.
Yeah. Right. Right. Fresh start will find it difficult to start off. Yeah, but policy level we need to push forward, because there's a whole benefit of bankruptcy and insolvency as visualized under the IBC Act. If they have to go beyond the corporate thing, so we have to make this work. Otherwise, IBC will remain only for the corporate houses, and the individuals and such segments will somehow, because of the implementational challenges, will remain out. But debt is equally debilitating for individuals. Of course, we should not be always banking on these debt waivers, etc. Right? So therefore, we need to somehow institutionalize this process even for individuals. So the institutions definitely need to internalize this fresh start process and individual bankruptcy as part of their resolution process, debt resolution process internally, right? So they have to find mechanism. One thing, of course, first level, I would like to say that in terms of its impact, though microfinance, small finance bank, and even other MF sector formally are little wary of it, but demand will not go down. Demand will not go down. The demand from the small segments can be met only from such sector, such institutions. Formal institutions will not reach out to them. So therefore, microfinance institutions, NBFCs, SFBs, etc. So their demand in no way is going to decline. So that is for sure, right? Though they may do recalibration, as I said, they may do recalibration in terms of the type of security, because they may add a hypothecation, etc. Second thing that they will do is also again to come out of the fresh start process, because fresh start process the limit is 35k, 35,000 rupees, right?
Right.
Yeah. So already as per the RBI definition of microcredit loan, it is 1.6 lakh. 160,000 is the microcredit definition. So they will again ensure that at least for, if not for all, for many of the borrowers, so they possibly would even lend little higher, so that they automatically also get excluded by way of size of the loan, right? So therefore, there will be various kinds of calibration, but policy level, we have to ensure that they internalize this, they don't totally evade this, and a good amount of information and extension has to be, information dissemination extension has to be carried out both among the borrowers and among the lenders, that this will be a win-win situation both for them. So it is not like a debt waiver, and it won't overwhelm like debt waivers. Of course, debt waivers in some cases have overwhelmed the formal institutions. So, but we have to ensure that this will be a case by case basis. Not everyone applying will get it. First of all, they have to apply also. Unlike loan waiver, it is a general pardon. Here there is no question of general pardon. So these issues have to be argued out with these institutions. So they necessarily have to internalize, and it should, because as I'm visualizing that the demand will not go down, so therefore the problems of debt and repayment will remain. And with pandemic, of course, in the recent period, right, it has also created a lot of difficulties. So we need to bring in this mechanism as an additional mechanism in addition to the existing mechanism. So that is the way forward, I think.
Absolutely, sir. Ekta, so I think we can move to the next agenda now.
Yes.
Yeah.
So our second agenda for the discussion is there a possibility of abuse of fresh start despite extending the cooling period from 1 year to 5 years? I'll give everyone a small brief of it. As per section 82, 80 subclause 2 of the Indian Insolvency and Bankruptcy Code, it says the eligibility criteria is on the debtor's history of availing various insolvency processes. Now, Section 80G lays down the person who has availed the fresh start process in the preceding 12 months from the date of application will not be eligible for the fresh start process. We would also like to tell you that the committee has agreed that the cooling off period mentioned in Section 82G should be amended to increase to 5 years instead of 12 months. So we would want your deliberations whether this cooling off period is sufficient to safeguard the process from being abused. Shailendra sir, may I have your views on it?
Right. Yeah. Yeah. We had debated this as part of our working group, right? So the whole issue of cooling off period, and then the 12 months being prescribed. So is there a constant tendency that every year I can avail this? Right.
Yes.
As I said that no, it's not. Even of course, theoretically say that it's going to remain as 12 months, right? So it's a individual effort is required, right? So they have to apply, right? There are a lot of issues there. So it's not that people are just queuing up. Even if it is 12 months, they would queue up that every year I will, because that means they know that particularly now, even with credit, what is that credit scores being operational now, right? So the credit scores. So even in the microfinance sector now during the pandemic, so people were worried about their credit scores. My interaction with the SHG sector has revealed that they were also worried about the credit scores. Not that they will just because it is there they would avoid. General pardon, it is fine. General pardon like debt waiver, it is a government policy or it is a lot of politics. So it comes out of blue, it will come for them. Whereas here, it's not that easy. So that is anyway first level argument. But the argument that whether it should be 12 years, sorry, it should be increased from 12 months to uh, 5 years, the cooling off period. 5 years, right? So recently some committee has recommended that it should be 5 years, right? Yeah, so I would somehow I'm wary of that. I'm wary of that for precisely because as I said that there won't be so much of spy. What is this? We used to see in the COVID, surge for COVID bed. There won't be surge of people for every 12 months they will come there. That won't happen. But we can put in even if we retain this, we can put in certain norms, right? For example, if they have availed a debt waiver by chance, any kind of a debt waiver, like we are saying about particularly also housing, if they have availed debt waiver, no. If they have availed insurance benefit, because most of the MFI institutions, formal institutions, they also link their loans to insurance, right? It may be crop insurance or other kind of insurance, right? So if they have availed any of those benefits already, right? And if there is some amount still pending or they still want to come forward, right? So those kinds of restrictions we can put, right? So this 12 months, of course, probably because it's likely that in agricultural sector, I would say, so there is repeated difficulties farmers face. Sometimes for 2-3 years continuously they will face drought or no famine situations continuously in agricultural situations, right? So yeah, so therefore it's not that easy for them. So even just 1 year of waiver also does not help, because next year also they have faced repeatedly. So agriculture being so vulnerable to climatic effect, so there it might become useful. If you, of course, if you are going to institutionalize this in a very systematic way, and that institutions will not be overwhelmed, but there are certain norms and restrictions. So subject to that, continuing with 12 months is also fine. That's my view, right? Because agricultural sector, right? If there are, because where are the suicides happening, right? Farmers are committing suicide. One of the reasons is debt. And sometimes these continued failures of that happens sometimes because of climate, sometimes because of the price crash, and for various pest attack, various reasons, they will every season they will have difficulties, right? So in those kinds of cases, so therefore the resolution professionals also have to play a proper role in assessing this, right? So as I said that it's not a general pardon, things can be tackled case by case basis. Even if it remains 12 months, it is that's fine, my view.
Okay, thank you, sir. Professor John, the debt relief order in the UK has a process like 6 years is the cooling off period which has been given there. So how do you think, would that be, we would like to know your views on it. Like,
Okay, yeah, so I've got 4 points that I'd like to make. The first one reflects my earlier comments around creditor behaviour, and the idea that well, debtor behaviour as well, actually, but it's the point about the 2005 research. So basically, it was me that did that research, the empirical research for the Insolvency Service, because when we reduced discharge in 2002 from 3 years to 1 year, there was a suspicion that by the press mainly, it was actually driven by the press here, that the reduction in discharge would lead to greater use of bankruptcy, and that it would become a a feckless debtors charter, and that you'd get serial abuse of the bankruptcy process. What that the researchers I mentioned earlier showed that was no, that doesn't really happen, because people are just under insurmountable debt that they just need a relief mechanism from, the kind of suicide point that Professor Shilindra just mentioned. So building on that point in relation to your sort of repeat use of a procedure point, I'd say that there isn't evidence in English and Welsh law anyway of that kind of cynical debtor behaviour. That's the first point. The second is that what we have done, though, and this is not in bankruptcy, like not in DROs, but in bankruptcy itself, as part of those 2002 reforms, we introduced a kind of balancing mechanism, which was a reduction in discharge from 3 years to 1 year, so that you'd be automatically discharged after a year. But the quid pro quo, or the balancing of that reduction, that relatively quick fresh start mechanism, as we call it here, was that we have quite punitive bankruptcy restriction order mechanisms now. So we've introduced a kind of strong punitive side also to that more liberal relief mechanism. And what that would mean in the context of this kind of repeat use of an insolvency procedure is that the courts here are very strong on dealing with people that, and it's a very small percentage, as I say, of repeat users that abuse the credit system and then the bankruptcy system to get relief in the way that you're perhaps suggesting. So that's the second main point. The third main point supports Professor Shilindra's earlier point about credit and the effect on credit rating. So here, both bankruptcy and debt relief orders, the ramifications of that for your credit scores. And like from my phone, for example, I've got here Experian as I won't show you my credit score in case it's embarrassing, but we have the ability to check credit scores, as do credit reference agencies, etc. So in banks, lenders, and all that. So any use of these procedures has that salutary effect. So it goes beyond discharge. So it doesn't matter that you've been discharged or that you might use a DRO repeatedly within 6 years, whatever. Because credit references here last for at least 9 years, you've still got that taint for you. And then the other thing, and the final thing I wanted to say on this point about time. So for me, it wouldn't be so much about time until you used another insolvency process. For me, it's more about the time within that insolvency process, and that goes back to that discharge point of reduction from 3 years to 1 year. So the sooner, for me, you can get in and out of an insolvency procedure to get back to normal life, be rehabilitated, have that relief, don't suffer the potential stress that could cause a farmer to commit suicide, etc., the better. So, and if that meant that you went into another one, within 2 years or 3 years because you needed it, because you satisfied the criteria for entry, then you satisfy the criteria for entry. I don't think we should inject subjective ideas of Machiavellian behaviour of debtors into this when they're languishing under the kind of pressures that have been outlined. Sorry, they're my 4 points.
Thank you, sir. Thank you. They were very insightful. Renuka ma'am, do you think that what Shailendra sir said has given from Indian perspective and John sir has given from UK perspective, your final inputs on this? Ma'am, you're not audible.
So I said I agree with the two of them because, as I had mentioned earlier, since this is a systematic process where there are records of who has availed a fresh start and who hasn't, and this record goes into the pricing decisions the next time around, as long as this information is available to the credit industry, I don't see why, even if somebody took a fresh start every 3 months, okay, that person would have a trade-off in terms of the kind of credit someone is willing to offer to that person at whatever rates this particular lender wants to offer to that person. So, if we believe that the credit industry is rational as we know it probably is. It worries about its own interests, and debtors also see the trade-off of taking a fresh start today because it might mean more expensive credit tomorrow. I don't see why we have to come in and put out these kind of what I think are artificial stops in terms of how many months or how many years should there be between two instances of taking a particular fresh start. So I agree with both the speakers.
Yeah, just one more point. Can I add? Can I add?
Yes.
Yeah. So, yeah, what is likely to happen if those kinds of no again you put restrictions, right? Even if you put a restriction of 5 year, right? So, there used to be, in the case of regional rural banks, loan restriction used to be there because they were small banks. So, small loan limit used to be there, right? So, people knew how to overcome that, right? So, today, this year I will borrow, next year my wife will borrow, or together, my wife and we will take loan separately. So, we will overcome that size limit. So, here now also, so I will make, if you put a restriction, but if that is going to deprive me of this benefit, possibly I will, as a borrower, resort to different strategy. So there will be different members who will borrow. So then what will you do? That household will continue to get the benefit,
Yeah.
right? Even if it, huh? So that is possibly the kind of strategy the households would adopt.
Absolutely. And one more thing I think what we need to remember is that in India, we often have a lot of restrictions on the lenders in terms of the interest rates that they can lend at or the amounts that they can lend to a specific debtor. So, to the extent that these restrictions remain and creditors can then not price the loan, you realize why policymakers then want to put in restrictions from the demand side as well. So perhaps, in my view, the way forward would be to also remove restrictions or at least liberalize some of the restrictions on the lending side so that credit decisions can be made or interest rates can be increased or there can be a differential pricing depending on who you're seeing as a potential debtor, because then that sort of allows the market to function and have a demand supply solution so that different people then are able to get credit at different rates. So to the extent that you stop one pipe, which is you say to the lenders, you can't lend beyond a particular interest rate, you can't do XYZ, you can't lend to a person like this and a person like that, then you realize why there is a requirement or why policymakers begin to think that I now need to put some restrictions on the demand side as well. So I think that's the cause of why there is this restriction of 5 years. But I think that it needs to be handled by also allowing different kinds of products and different kinds of pricing to persist.
So, if I were to summarize the entire thing, I think what you all highlighted was that as long as there is information symmetry in the market, that credit history and all these information is readily available, then market forces are, competent enough to tackle this problem. But if we sort of, increase the cooling off period from 12 months to 5 years, like Shailendra sir also mentioned that there are problems like agriculture where, it could persist for a couple of years together. So those people won't be able to access this. And secondly is that even when you extend, there are multiple ways in which you can abuse the same. So yes, I think a combination of both, having a proper information symmetry in the market, and also like Professor John mentioned, some punitive actions from the side of the court is also something that can be looked at from the policy perspective. So, Ikra, can we then move to the next third agenda?
Yes.
Can I just make one
Yeah,
quick
sure.
point, which is, I
Sure.
suppose if you've got the in the next point of the agenda, we mentioned the government functionary, the office holder who deals with the process,
Right.
and I suppose on the points of bringing together the agricultural point and then repeated use or entry. if that person, that government functionary, had the discretion to be able to evaluate each case on its merits pursuant to the criteria and apply that in the agricultural sector, I think, as was alluded to earlier or directly mentioned, that 1 year you could have a flood, you recover your crop, the next year it's okay, but then you have some other catastrophic event that's well beyond your control because of the unique nature of agriculture. And those systemic things that are outside your control surely shouldn't preclude you from accessing a debt relief mechanism that you need because of no fault of your own. So artificial barriers that are based on a length of time that don't have subjective or specific evaluation seem to me problematic, particularly when you've got a government office holder who could perhaps make the decisions about use as a gateway. Yeah.
Right. Rightly said, sir. And this also gives us an opening point for a third agenda. Now, they say that the IBBI has envisaged authorized officer who will be responsible for overviewing the whole fresh start process. Now, the purpose which is given is, they say they want to reduce the cost. But however, we feel that there is a possibility of interest in the way AO functions and the IBBI. So, Renuka ma'am, your views on it, because we personally feel that there's a dedicated officer would definitely, if he's going to supervise the whole function of the fresh start, there might be conflict of interest.
Yes, I mean, this is a difficult one to comment on because, again, often one has to think about why there was interest felt as to we should put this responsibility with the IBBI instead of the court as is done in the US or the UK. And that's because we know that we have a significant problem in the functioning of the courts. And, as earlier envisaged in the law, if all of this had to be under court functionaries, then it is possible that this process would not move at all. So the trade-off that we are now thinking about is whether to put it under courts or whether to put it under IBBI. And for many reasons, in terms of speed, I would think that the regulator is a better option in India than the courts are. The whole design of the IBC, for example, has shifted the locus from the courts to the regulators to the extent possible for these reasons, and we will apply to the fresh start as well. So yes, I think that it's better done under the IBBI than the courts at the moment. However, how to balance the conflict of interest question, I think, is a very valid question as well. And, there may be ways in which the final order is signed by the court, perhaps, where unless there is a way to appeal the order of the IBBI, as in many other instances, if you don't like what the regulator is doing, you can appeal to the court or appeal to an appellate mechanism. And of course, this is harder to do context of individuals who are certainly not very empowered to make, to go to courts and actually make these appeals. But perhaps there can be mechanisms like this or an oversight mechanism that can deal with the conflict of interest problem. But yes, I would think that several parts of this process of making the application, getting someone to check and validate whether this is the correct application or not, calling the creditors and seeing if this is okay, whatever the process that we ultimately decide on this is better done at the regulator than at the court.
Rightly, ma'am. We do have a similar point. John, sir, your views on it. Do you think that it would be better to have it on a regulatory perspective or a personalized officer handling these processes?
Okay, so there's sort of three main points that I'll raise on this. So the first one is about officialism. So in English and Welsh law, since the 19th century, really, we've had a tension between whether or not the public office holders, so the government, administer insolvency, or the private sector in terms of profit-making insolvency practitioner. Over the last sort of 2 decades or so, with a reform to bankruptcy, which was the debtors' petition, which were taken in-house into the insolvency service, so made part of government process, So that's the bankruptcy debtor petition. That is now an online process with no court involvement. And then the other creep of officialism, so the other way in which the government have started to creep into insolvency administration, is that, as you're suggesting, the debt relief order, and that's because of the authorized intermediaries, these people who sanction the process. So what that means is then that the shift has begun or happened from private to public sector, so to the government, which led one commentator, Ian Fletcher, who's he's sadly passed away, but was a big authority on insolvency issues, to talk about the slow disappearance of insolvency procedures in terms of how you can critique and see the operation of them, because if they go into some big administrative government office, is that a problem because they're less opaque? And that links to my second major point, perhaps my final point, which is when those reforms to the debtors' petitions for bankruptcy were first mooted and they've gone through, the judges severely reacted in the negative to that. They were very displeased, and the reason was because they thought that the debtor, indeed creditors as well, because we're talking about collectivized debt remedies, with multiple creditor participants, should basically have their day in court, so should be able to air properly and formally through the justice system the various aspects of their case in what is a very fundamental underlying credit relationship sense. So that means really in England, just to conclude, you have a push by the government, and there's an argument that the agenda for that, or what sits behind that, is to get more fee income into government. So it's about money and finance, versus the judges who are basically saying, no, these processes shouldn't become administrative. They should be in the court because they're about important legal issues that should be in a court, not in a administrative officer's command. So yeah, there's some brief reflections.
Great. So, sir, you were saying there needs to be a proper formalized process, even if it's done administratively or a judicial manner. Both
oh yeah, there definitely needs to be a process whereby these mechanisms are administered. And I get the point that Dr. Anuka was saying earlier about that there's systemic court problems in India that mean that it's better to do it through government agents, and there's an argument for that here, in that you could say, particularly with Corona and with the tsunami of insolvencies that's about to happen, that we're going to have, the courts are going to be overburdened with corporate insolvency, let alone personal insolvency issues as well. So that, and also it's job creation for government employees. Why not give some government employees some stuff to do? But which is a good thing. So yeah, absolutely, there has to be a proper structure. The problem is if that structure leads to a lack of proper oversight of these important processes of debt relief that judges, for example, bring to bear on the whole process, then that could lead to problems.
Right.
Just a little, just one point I think we'll have to mull over is that if you create, if you give the powers to the regulator, still you cannot oust the judicial scrutiny. And as Renuka said, then probably for the finality, to get the finality, you got to go to the courts to get stamped. So, sometimes what we do in the process is we create an extra layer of scrutiny. So it is not really eschewing you from going to the court. In fact, you'll have to go to the court, but just that the involvement is less. So, sometimes it just delays the process because ultimately the power would rest with the judicial authority and not the regulator. Also, I think, I'm sure, Ekta, this question is lined up for you, is recently Indian Supreme Court has decided that when it comes to private parties contracts, you cannot waive the rights or the interest of a loan which is through private party contracts. So the larger question here is, when a regulator or the policy in form of law later steps in, I mean, will it really see the light of the day? And that becomes more vital if you give the power to the regulator to decide. And so I'm just saying two things we need to be conscious of. Are we creating extra layer, and which can also be more subject to abuse, delay, etc.? Second question is that if at all you'll have to go to the court to get finality, should you rather wait and empower the courts, and you go at the last instance? So one way could be out of court settlement through mediation, and just for the order to get a stamp, you just go to the court. So you leave it totally to the participants how they do it. And they could take an RP, they do it out of court settlement, and they just go to court to get a finality. And the larger policy question, I think Renuka would be better to answer, and Professor Shailendra, and of course Professor Tribe, coming from the common law perspective, is it really open to the courts fundamentally to create a scheme of law? Because there's a conflict in equity principles. One side equity says that you have to rescue the weak. The other side equity says, you know at least commercial equity would say, you're not supposed to step in and rewrite the contract for private parties. So how do you sort of balance these two fundamental, stalking, contrasting ideas? So yeah, Renuka.
So, Didi, I just want to add one thing to what you said, which is that, the structure of the procedure also perhaps depends on how debtor friendly the process is. So, for example, if your conditions for getting a debt waiver do not require proving multiple things, then it's perhaps easier to get a debt waiver because it's structured such that the default is that when you apply, you are more likely to be granted a waiver than if it was more creditor friendly, where you had to prove each time that you absolutely cannot pay. So I think that how the structure is designed will also shape how long the process takes, and hence what are the multiple layers we are creating and what are the delays we are introducing in the system. So I think that we need to think about that as well. But the point on multiple layers was certainly very well taken. We know that we've all suffered it in one way or the other, in the way many things work in India.
Right, ma'am. You have said that multiple layers will definitely would be again another huge conflict of interest. Shailendra sir, your views to sum up on this discussion.
Yeah, the committee debated, because 2 points before I share my views is one is currently in all the new farm laws, one of the contestations by the farmers is that the new farm laws have taken away their right for legal recourse, civil court recourse, right? So they are agitating over this point also, because they have brought in bureaucracy to settle the contracts, farm contracts, right? So that is one of the contentious issue. That is a contentious issue, whether it is for farmers or for others also. So now in the committee, our debate, particularly with regard to fresh start process, was also influenced by the fact that for the individual resolution, right? So the argument was that we need to have an alternative mechanism. So the regular mechanism, the formal court mechanism, so when it comes to individuals, would be some, and there could be several kinds of issues that could come up. So therefore, alternative resolution mechanisms were discussed, right, as part of the individual bankruptcy issues. So therefore, as for fresh start process, it was felt that these are all people who are of acute situations, right? Acute situations. So it's not that easy for them to even to sometimes go through these alternative mechanisms, right? Right. So individuals, bigger individual loans, those can probably even go for individual mechanisms. But here, these kind of acute cases, even for alternative mechanisms, they may find it difficult. So we discussed various alternatives. one of the alternatives that was also being discussed was we can possibly make at the district level, no, district magistrate, no, these are IAS people, possibly they will resolve. So those kind of discussions also happened, right? But then it came to a point that possibly these local officials, they are all under the state government. They will come under the influence of the interference of the state governments when they adjudicate, right? So there could be a call to even to the DM that our we have sent so many applications. Why have you not cleared? There will be pressures on the district magistrates, right? Who are bureaucrats, basically bureaucrats. So therefore, given this argument for alternative thing, so though we need to evolve, so given the kind of challenges that was there, so therefore this was a second best option that possibly to make a start. Otherwise, if you leave it to the state governments and state government agencies, it will become very, very complicated. It may not take off. Just to make a beginning, given that IBBI is a regulatory body, there will be a lot of responsibilities to ensure that there is no any kind of a bias or any kind of unfair thing. So they will possibly put in place safeguards also, right? Conflict of interest might come in, but not of the kind that we expect normally. But they can possibly put certain safeguards. There could be reviews, certain kinds of reviews that can take place, right? Apart from this ABO. So this was therefore thought of as an alternative mechanism to the regular courts, even regular alternative mechanisms, and over the state level bureaucracy. So this was thought of as possibly the best solution. So I would suggest that, yeah, given the circumstances, this is the best possible thing that has been identified. It can be there as again as a sort of a stopgap arrangement. We can experiment with that, right? And then review it also with safeguards. And if there are any problems, so then we can think in terms of alternatives. Otherwise, any kind of mechanisms for these kinds of acute situations, because these are all low income, poor, and people who are ridden with crisis. So any kind of hassles, etc. So it will literally will demolish that whole purpose itself, right? So therefore, this is a second best option, and we can try with that and review it subsequently. Then maybe put in any other best by that time if alternative mechanisms for individuals would have come up. If that is competent enough, that is capable, then we can possibly transfer this to the alternative mechanism that is being discussed for the individual cases.
So like you mentioned that out of the various alternatives, having the IBBI take charge of this seemed to be the best alternative as of now, given the current circumstances.
Yeah.
So I have a question that given the current design of the pre-pack that is being envisaged, where it is moving towards automation, where the AOs will have lesser power, do you think we should bring in mechanisms to restrict the parameters on the basis of which, an application is rejected? So that the discretion or the power that the AO has to reject applications is reduced to a great extent, and it's only on certain parameters that he can reject. For example, the documentation is not proper or things like that. So what is your take on that, sir?
Yeah, so of course those criteria currently they have been specified, right? There are 3 or 4 criteria, right? Loan size, asset size, income size, and housing also. Additionally, housing is also there, right? So they together put together literally make it a very difficult proposition to take this forward, right? Not many will together satisfy this, right? It is a very difficult. So those criteria are highly restrictive. So I was of the view that probably because anyway this overall loan size is limited, that you can keep. Maybe you can little hike because given this was proposed 5 years back for the current price level, maybe you can little increase the loan size, just keep the loan size, and then first level ensure that there is some kind of a diligence is exercised that the farmer or any individual microfinance borrower, they have suffered in some way, right? Maybe there could be flood, there could be drought, those kinds of situations. So therefore remove those additional restrictions because it will become difficult. So keep one, and at least on the assessment side, what caused this? If that is a convincing thing, that if there is a flood, the flood has happened, drought has happened, right? And anyway, you are saying that it is 50K, 50,000 rupees. So that should be good enough to upload, qualify that application, right? And then the AO can further verify. AO, right? When it comes to AO level, so he or she can apply another level of vetting, right? Another level of due diligence. Right? Did this happen in that district? Did that individual face? If they require such things, so therefore that will be the second level. So therefore, criteria need to be relaxed. In my view, if they are too restrictive, then again we are not helping in this case. Right. Yeah. So if it is only single one or two criteria based on assessment, that will make it easier.
Absolutely. And
Can,
yeah,
can I
Professor.
just make an observation on this sort of criteria-based point? So remember earlier on I mentioned the bankruptcy procedure had been taken in-house into the insolvency service, so part of the government, and that the key functionary, the key government official who would then deal with bankruptcy debtors petitions is known as the adjudicator. So it's roughly analogous to the DRO officers, in that they're a government official who makes decisions on behalf of the government about entry of debtor into an insolvency procedure. So there was a case called Budniok, where the adjudicator, so the government official, had to decide the criteria for debtors' petitions in bankruptcy, and one of those criteria is whether or not the debtor has their centre of main interest, if they have that their location in England and Wales. And the problem for the adjudicator, so the government functionary, was that Budniok was German in terms of nationality. So the question it had to resolve was whether or not the flat that Budniok had in London was sufficient enough to mean that he had his centre of main interest in England and Wales and therefore could be adjudicated bankrupt. The adjudicator said that he didn't have his commie in England and Wales. That was then appealed, so out of the government, appealed to the judges, and it was the judge at the time, the Chief Bankruptcy Registrar, Registrar Baster, who decided the opposite. So the judge decided that Budniok, the German, did have his centre of main interest in London. So in terms of entry criteria, you can see then that entry in criteria in this case from bankruptcy or of a debtor's petition anyway, in terms of a government decision went one way, the government office holder, the adjudicator, and then the judge's decision went the other. So I suppose what this means for any criteria for entry, but just so happens in this case whether or not the debtor is located in a specific country, is that criteria has to be super clear to ensure certainty and stability in the system. So that was an interesting thing, and also in a certain sense where we discussed earlier about officialism and the tension between the judges on the one hand and the government on the other. This in a way is like the judge's revenge by overturning the decision of the government, but I won't expand on that. So yeah, it's an interesting case, Budniok, on these tensions. Yeah.
Absolutely.
Sorry, that was the point. Yeah.
Yeah, I think it's an interesting case, and we should all have a look at it. It will give us a lot of perspectives into this issue. And Renuka ma'am and Neeti ma'am had mentioned just now that regarding courts having the final say. So our next point of discussion would be that we are saying that one of the very interesting things that I noted in the report of the committee was that they have mentioned that due to the increased costs, there may be borrowers who may not be able to pay the stamp duty to appeal to courts, and it will be a costly process, and hence the regulator should take this over. But then what about the appeal? So the committee says that in case you have the aggrieved party can go to DRAT, which is the Debt Recovery Appellate Tribunal, for any grievances that they may have. So do you think a borrower who cannot afford to pay the stamp duty on court cases, is DRAT the correct forum for them to apply? And if they are actually applying to that, then how will they bear the cost of the same? So Renuka ma'am, I would like to have your inputs on the same.
Sure. So the one way out of this is to, perhaps there will be like legal aid organizations that help with the appeal, or that help with accessing courts. So what we need to do is to build a mechanism through which there are two ways, right? One is legal aid organizations that help, or consumer organizations that help debtors, and the other is some form of subsidy that the government itself might give in terms of how and when you access the insolvency procedures. So different countries have taken a different stance on where this money comes from and how it is financed, and one has to look at the various models and see which is the one that works best for India, because as with everything, there are obviously trade-offs in which model you choose versus the other. But my bias generally, or my preference generally, is to not do things that will incentivize people to behave in a particular way, but to then give subsidies from the outside. So, as an economist, I would always say don't mess with the price system, but, give lump sum cash transfers. This is in other contexts, of course, to solve the problem of poor access. And so I would sort of apply that same lens here and say that let the costs be they are, and find other mechanisms of getting vouchers or subsidies or cash transfers um, separately for these people to access some of these institutions.
Absolutely. Shailendra sir, your inputs on the same. The thought behind having DRAT as an appellate tribunal, is it the correct forum, or should we come up with an alternative?
Yeah, for the fresh start, of course, the whole issue of cumbersome procedure was the major issue as to why AO was put in. Right. Yeah. So now even for the appeal, right? Of course, natural justice requires that we don't prevent anybody to have recourse to the regular court process. Natural justice, right? That is a right. They can have that. That can be specified, right? So now even the farmers are also demanding, because in the farm bills, government is not giving them that even that option, that option, right? It will be bureaucratically settled, etc. Because in the farm bills, interestingly, if you look at, some of the state governments had even more progressive kind of a no dispute resolution process. They had even appointed separate tribunals in the case of certain marketing or contract farming issues. But now this new bill, farm bills, even nullifies those things, right? Those kinds of things have happened, right? So we cannot, for the citizens, deny those rights, those rights of natural justice, legal recourse. Maybe that can be there as a last resort, right? As a last resort, if it is there, so therefore we are sound on the legal ground. But operationally, what I would suggest is that, so let AO be there, right? The DRTA is a legal course, right? Final recall course. I would suggest what, like for example, Supreme Court, right? You have a scope for a review application. We have a scope for a review application. So therefore, those cases which have been rejected by AO, right? There can be a review application. Maybe an NGO or someone who possibly knows the situation on the ground. So with for further facts, further information, etc., they again go for a review application. Maybe again with the AO, right? So possibly IBPA can, for review applications, possibly can have an alternative mechanism there itself. Maybe somebody else would look at it, if not the same judge. Or even the same AO can look at the review case if new facts have been brought forward. So, therefore, have this additional review thing, and that might help, because there could be situations where the judgment has been possibly erroneous. So, during review, possibly, if new facts have come up, right, then it might possibly redress the grievance that would have happened, right? So, that is my thing. So logical, legally, theoretically, we should not foreclose any kind of opportunity, okay? Because that is against their right, right? So that is the kind of lesson that is also coming out from the farmers' agitation. I am referring to it because that has become also an issue there in the farmers' current agitation. They are saying that we can't go to civil court, right? You are asking us to go to bureaucrats, so who will generally favor the well-off like that. So this is my, therefore, additional suggestion. So AO and a review application. Again with
Absolutely.
the,
Yeah.
before going to even DRAT as a last resort, within IBBA itself, there should be a scope for review application.
You're absolutely right, sir, that we cannot prevent anybody from having access to the courts of this country. And that is something that should be readily available for all. But at the same time, when we try and say that we are moving it away from the courts to a regulator to, in fact, address the issues of cost, time, all these things, then should this be the final appeal? That should there be another body which looks into it? And very interesting point has been brought forward by you, that there can be a review application which is looked into by IBBI itself, other officers, obviously senior officers, but looked into by IBBI itself, that the regulator body itself. Professor John, your inputs on the same?
So yeah, we actually did deny those rights in a case called Regina and Lightfoot in England and Wales. So I'll just reflect a bit on cost, and then I'll get to that judgment and what the reasoning was for that judgment. So there are two main points basically. The first one, again, to go back to 2005 in that empirical research, one of the respondents, so it was about how those respondents use bankruptcy courts and the bankruptcy system. One of them responded in the survey, why, and then they used a rude word, so why the beep beep do I have to pay £750 to declare that I'm bankrupt? You know, intuitively that kind of makes sense, doesn't it? The idea that why should I pay to say I've got no money? And it raises the point that was made in that case that I've referred to, Regina and Lightfoot, because Mrs. Lightfoot basically thought it was her right, and indeed she went to the European Court on Human Rights, ultimately the appellate court structure, to test the idea that it should be her right as a citizen to access the bankruptcy provisions. And basically the court held that that wasn't a human right because it was an administrative process, and that administrative process needed to be paid for. So the official receiver, actually, that even though it costs £750 to enter bankruptcy here, the actual cost is about £2,000 to the state. So like it's subsidised already by the state. So it wasn't a breach of her human rights. Instead, it was the reality that procedures have to be paid for. And on which point, I can share an article. I've just shared an article by a law firm that summarises the Budniok decision, but I'll share another article in the chat function that discusses Lightfoot, but also discusses the idea of sliding scales. So in English and Welsh law, up until 1971, we used to use bankruptcy revenue stamps, a bit like I think you use now, where your court fee is represented by a stamp that you paid for. And those revenue stamps in England and Wales used to be on a set fee. So the different stamps, I've got some here actually, I don't know if you can see them on, I'll try and show them on the thing. Yeah, those stamps are a bit, yours might be the same, I suppose, where they're at different fee income levels. So, they cost different amounts each stamp. But these are obsolete now here. But what that made me argue in that paper that I'll circulate is the idea that perhaps we should have a system here whereby if you have higher amounts of indebtedness, so let's say you owe £10 million, your fee for entering bankruptcy should be higher, let's say £10,000. But if you're much lower, it should be again on a sliding scale. So that was mooted. But I suppose the argument against it is that you could have it introduces administrative difficulties potentially on who quantifies what, and how do you sort out those scales and so on. But it does raise the important point that, particularly in the context of NEMA or low income, no asset cases or DRO cases, where the fee is much lower, by the way, than bankruptcy. So we're talking £90 here at the moment to enter that process, and it can be paid in instalments, that fee. And what that means is, of course, like you both panelists were discussing earlier, we're talking about individuals who have very little income and very little disposable income to pay these fees, that how do you resolve that intractable problem of financing an insolvency system? And I think the point that was made regarding, well, charitable work that can pump money into fee payment is interesting. But for me, more broadly, actually, the state itself perhaps should also provide more fee responses. And then my final point is that, and it goes right back to our beginning of our whole session today, in my first comment about debtor friendly, creditor friendly, and the points that my co-panelists have made on sophisticated credit industry. This is a two-party bargain. We wouldn't be where we are but for the extension of credit. Perhaps there should be some sort of levy on the credit industry that also helps these pressure release mechanisms work properly. Yeah, that's it really. Oh yeah, I'll just share that article as well.
Yeah, so there are arguments on both sides of it, and I think, like you reiterate the points mentioned by Professor John and Renuka ma'am, the state should bear some of the burden of this cost, and that is how it will, it'll be accessible to all the people, especially people who are falling in the low income category. Neeti ma'am, you wanted to add something? Okay, so I think there's a connectivity issue there.
No,
Yeah.
sorry, I was on mute. No, I just a very quick point I wanted to make on what Sharendra sir suggested, that somebody from IBBI could itself review it. I think that will really go against the cardinal principle, where a person who's ordering itself reviewing. So I'm not sure how that pans out. Also, I still remember there has been a lot of debate about giving powers to the regulators for, I mean, one of the fundamental questions in farm laws is also, should executive get the power? And we should not forget that the same sort of concern would apply here, because IBB as a regulator is basically a body made of, bureaucrats. So the same concern would rise here. So just a point to that, yeah.
Okay, fine.
Yeah, so now the next question that we have, the next agenda that we have, is more of a policy question, that the way the provisions of this fresh start process have been formulated is that any person having a dwelling unit is not allowed to apply for this process. But if you look at the latest report of the committee which is deliberating on the fresh start process, they have mentioned that houses which are located under a government scheme, central government or state government scheme, they should be excluded. But the larger question is that should dwelling houses be allowed within the fresh start process, or people having dwelling houses should be forbidden from accessing this process? The reason being is that this is more of a question of discharge principle, right? So houses are usually the most valuable assets that debtors have, and just because you have a house does not mean you are a wealthy person who can pay off your debt, because that house is something that could have been carried forward through ancestral property. It could have been an ancestral property. So should the process take a more humane approach to say that, okay, let's allow people with one house to apply for this process instead of forbidding them from accessing this process? And if I'm not wrong, even the DRO processes under the UK forbids people having dwelling unit from applying for the DRO. So I would like to hear your views on this, Professor John. Do you think this is something that should be looked into?
So I think, don't forget I'm debtor friendly, so that again, that taints my responses, because again, the points that have been made earlier about sophisticated lender decisions based on various criteria that come from the credit industry are geared imbalanced, in my view, in a very strong way in favour of creditors. And what that means in English law, I suppose you could say English and Welsh law, with bankruptcy, where the house is available to those creditors, that to some extent you could argue is a highly unsatisfactory point. Your point that it's the most valuable asset is of course, true and why creditors can go after it. If the trustee in bankruptcy hasn't used that asset, so hasn't sold it, and then realise that value for the estate after a certain amount of time, then it can revest back in the debtor. And on that point, actually, Jersey law, so one of the Channel Islands who have their own legal jurisdiction, one of their provisions, Article 9 in their bankruptcy code, which they call actually disaster, from law French, which means disaster. So their bankruptcy code is called disaster in Jersey, which is quite good. But they have a revesting provision. So basically, it means that in their disaster procedure in bankruptcy in Jersey, the family home can be put into the wife's name. So the other point, though, to note is that what we have here. So yeah, the house is the most valuable asset, but then what we have is lots of activity whereby the spouse, and sometimes this is game playing, but other times it's legitimate. The spouse does as much as they can to try and ensure that value is reflected in the spouse's interests. And so we see a lot of argument by trustees in bankruptcy and then spouses around the idea of common intention constructive trusts. So the extent to which a beneficial interest pursuant to a trust means that in fact the spouse owns in equity, owns that beneficial interest, where the legal title vests in the trustee. It means perhaps the house, only half the house can be sold for the benefit of the bankruptcy estate. So we have a lot of that litigation here, where there are arguments about whether or not there is a constructive trust, and if there is, then that means there's less value in the bankruptcy estate. I argued in a paper that's coming out later this year that there should be a presumption of creditor interest if there is a house that's being debated and a purported constructive trust. And you might all now be falling off your chairs going, well, hang on, you've been saying the whole call that you're debtor friendly. Why are you proposing that? Well, yeah, quite. I just did it as an intellectual exercise. But anyway, still, it was. It's not a popular paper because obviously it's creditor friendly, really. But so yeah, I think it's problematic that the house is available in bankruptcy. But you can see why it is historically, because of your value point. And if there are mechanisms like the trust that allow us to reflect family interests, and don't, we talk in the Cork report, which you might be familiar with. So the big command paper that led to the 1986 Insolvency Act. In paragraph 198 of that report, they mention the dependents, the family, etc., of the bankrupts, who are, of course, have no part necessarily in the reasons why there's a bankruptcy in the first place, and are heavily affected by the bankruptcy. So why make them suffer as well as indeed why even make the bankrupt suffer? So yeah, it's deeply problematic. Yeah, sorry, that was it.
Yeah, I reckon the major objective of having a fresh start or a DRO mechanism is to help debtors start afresh, right? That is the basic objective of having such laws in place. And having a dwelling unit acting as a hindrance in that process, I think that is something that needs to be taken care of. Renuka ma'am, your thoughts on this?
This is a difficult question to answer because of the points that have been discussed so far. However, I must say that I am sympathetic to the inclusion of the dwelling unit to the extent that while I'm also sympathetic to this being useful for debtors to get the debt off their back and make a fresh start in life, but to the extent that some part of the housing unit can actually go towards paying off some of the debt, we should find viable mechanisms such that there is some insistence on debt repayment. However, having said that, there are also difficulties in actually implementing this because of the points also discussed earlier, whose name is the house in, what is the value of the house very often. So, if I keep Fresh Start aside for a moment and I think of normal repayment plans, typically we will have minimum income that or sustainable budgets that we will always give the debtor so that the debtor can continue on with life while he or she makes the repayments. So similarly, bringing that analogy here, if the house is has very little value, and if you start taking that away, then we don't want debtors to be on the streets as well. So I think that this is, again, a balance between to what extent can the debtor maintain her life with dignity while accessing debt waiver or an insolvency mechanism of any kind, against, to the extent how much can we expect the person to pay. So my, a short answer to this long explanation that I just gave would be that perhaps there need to be thresholds around dwelling units and dwelling values. So instead of saying that, just home ownership as a yes, no, is perhaps not the way to go. And we've been discussing this in the committee, not with respect to Fresh Start, but with respect to how much of the value can the debtor keep once the debtor enters reorganization of any kind, and perhaps those kinds of discussions should be brought in into discussing the eligibility for Fresh Start or debt waiver per se. And the other challenge in India is, who owns the house really? Typically, these are joint families. Sometimes only the men own the house. Sometimes, if it's through a government scheme, only the woman owns a house. And how are we going to deal with, these joint ownership issues is a big question. And of course, it's been dealt with in other jurisdictions. But I think that the discussions in personal insolvency in India are not just for Fresh Start, but for other chapters as well, have not adequately taken into consideration this question of, what happens to the family and how do you divide the proceeds between the man and the wife, especially when female labor force participation is so low. So I think we need to bring that element into the discussion of the value of the home as well. So that would be my comments.
So maybe we can take some inspiration from the individual bankruptcy laws, where they state that dwelling units having a particular value are excluded from the estate, so they cannot be sold off to pay off creditors, something of that sort. And in addition to that, maybe having a threshold that if the house is worth 5 lakhs, you will still be able to apply for the Fresh Start process.
Or yeah, if it's below, right?
Below.
If it's below 5 lakhs, yeah. Yeah. Shailendra sir, your thoughts on this?
Yeah, I went through the note which you have circulated, Rustam. Yeah, and the item on this housing thing. Interesting that you have put that also. That's good. Right. And the point there being made that we have to have a humane approach in this, particularly for the Fresh Start process. Right. Individual things we can go differently. And then, of course, there also exemption is there, right? It is an excluded asset, right? It is an excluded asset. Housing comes as an excluded asset there also, right? You don't want to include housing because it is again a humanitarian issue. So you have excluded there. So then what about here? So therefore there is a contradiction that is well identified, and that also I also had identified during the course of our discussion in the working group, that you are excluding house in one case, and here you say that they are ineligible if they own. So contradiction is there, right? So here also it has to be excluded automatically. Even if you own a house, to avail Fresh Start process, your housing is excluded because it's a basic need. Yeah, so therefore, in principle, therefore, I take that view, because if the loan amount is so small, and automatically there is a relationship between the asset size and the loan. So those who own bigger assets, they will have bigger loans. Almost invariably, 90%. They are not eligible for. They will not come eligible for this Fresh Start process. So we are talking of low income, below poverty line, low asset, and such category of people. So therefore, the whole issue of humanitarian grounds becomes strong here, right? So, and by adding housing as a criteria, again we are killing this whole Fresh Start process, particularly in rural area. So what Dr. Renuka also mentioned, the whole issue of ownership, and then all the kinds of confusion that could come up. So if you take in rural, almost everywhere, 95% of the people own houses. It may be of different quality, but 95% or even more own houses in rural areas. Right. So this committee is suggesting that we exclude BPL, Indira Awas Yojana, Pradhan Mantri Awas Yojana scheme houses, etc. So that is one way of it, right? But in general, everyone who owns a house, irrespective of the quality in rural area, right? So therefore, how do you then, when you say housing, so theoretically, almost all will get excluded unless you are therefore going to make a gradation. BPL houses, Pradhan Mantri Awas Yojana houses, housing of this value, because you already put a value of asset here. What is the asset value for a fresh start process? something is there, no asset value 20k. Is housing excluded or included there? I don't know. Right. So therefore, that will complicate the whole issue. So this has to be much flexible, and humanitarian consideration both would suggest that we exclude housing here. So that is my take on housing, right? For individual, yes, you can have that, and it can become part of the resolution process also. You can add value, whatever you want to do that there, right? But for fresh start process, if you include it, it will not, this will also be another barrier for this scheme to take off, right? Housing assets titles are not that easy in rural areas, complicated, which Renuka mentioned, right? So variety of them, and so therefore it is better to keep it away on humanitarian grounds and on the operational ground.
So prima facie, there seems to be a contradiction between the bankruptcy laws and the fresh start laws. And rightly mentioned that if you have such exclusions, then a large pool of people will not be able to access the fresh start process, which will basically frustrate the entire scheme of things. So yeah, I think that was a very interesting discussion. Ekta, would you like to move to the fifth and the final agenda?
Yes.
So I've just shared a Jersey case that talks about that revesting provision, the Booth case that you can
So we'll
have a look
circulate.
at.
Yes, we'll circulate it amongst our classmates also after the discussion.
Cool. Yeah, that I've just put it in the messages area. There's also a message that's come in from
Shashwat.
Shashwat. Yeah.
Shashwat, do you mind if we take this after the fifth agenda? We can take it in the Q&A.
Yeah, sure. Thank you.
Yeah, thank you. Coming to our last agenda, and which is the minimum qualification requirement for the insolvency advisors, which is an IPCA, that's a cost accountant, company secretary, or a CMA, does not commensurate with the level of the fees or the amount of work involved. As a result, the professional will try to achieve the economies of scale by initiating higher number of cases. This may result in abuse of fresh start process. We have further bifurcated this agenda into sub 2 points. Should the minimum qualification for insolvency advisors be lowered? Further, the second point is, should the number of cases filed by an individual insolvency advisor be limited for a particular time frame, 6 months or 1 year? If not, what will be the larger impact of the credit institution of the country due to a high number of fresh start cases being filed? So, Shairendra sir, your views on the first one. Should the minimum qualification for the insolvency advisor be lowered?
Right. Of course, this is also linked to, of course, the issue of cost also for the fresh start process. Yeah. So my take is that no, we don't no reduce this qualification, right? So why I tell you, of course, my argument is that, right? So if someone is a low income patient, so which doctor would you advise? If someone is a low income patient, so we'll say that a lowly qualified doctor should treat low income patient. Should we say that? I see some such analogy or a parallel here, right? So therefore, how do we resolve this thing, right? Of course, because the whole issue of caste and and such things would come up. Yeah, so I would suggest two things. One, of course, in the panel also, in the working group also, we had discussed, and I also had suggested that at least for the fresh start process, and again to start with, IBBI can be meeting the cost, whatever the fee that they want to fix, they can fix, right? So IBBI can meet cost, right? One aspect of it, right? Operationally to take it, because at least for in these cases, a state has to invest, and there is a fund that is supposed to be created, right, under IBBA. So a fund has to be created for various such things. So this fund can also meet possibly the costs of fresh start process, right? So some fees can be fixed. And then the third, how do we then handle how do we ensure that there is an incentive, motivation for the professionals to handle this, fully qualified professionals? Of course, I am saying that fully qualified professionals, whatever the normal process, all the resolution professionals who handle any of the cases also should be handling this. There should not be any discrimination, right? So that's first thing. So how do we then incentivize? Of course, even if IBA is going to give some fee, definitely here the fee will not be very high, right? So I want to suggest here, yeah, somebody wrote that the pro bono work, right? Even if it is not pro bono, minimum fee can be given, right? Some minimum fee is given, and possibly IBBI will meet that. I would suggest this, that should become a criteria for any other kind of an assessment. If you are going to assess the resolution professionals for their promotion or any kind of recognition, so find out how many fresh start cases they handled, right? So some such criteria, they have to handle it on a priority basis. So all professionals must handle few such cases, if not many, right? At least few cases they need to handle this, because it is a kind of a social responsibility, right? So like we are saying now for the corporate social responsibility, for the resolution professionals, what is their social responsibility? At least handling few fresh start process, right? Some minimum fee will be given. Minimum fee will be given by IBBI, but it should come as a as a kind of a criteria to address the social responsibility, to review or assess the social responsibility by the insolvency resolution professionals. They will get minimum, and so that is how it should be taken, right? So because then therefore, because they know that this will be considered for other kinds of assessment. If I am not handling fresh start process, or if I have ignored them, there will be some discount. Of course, I will lose some money, but I will be discounted on certain other parameters of performance. Whoever does the parameters of performance, so bring in some element of social responsibility, because fresh start process in the entire insolvency thing is a different ball game. Unlike the corporate partnership or even the individual process, this is entirely different. The criteria and the norms here also have to be different for the resolution professionals. So that is my take on this.
Okay, sir, thank you. John, sir, in the DRO model in the UK, an office holder is acting, you have a debt advisor, right? Can you brief us about that and how that can be actually be aligned in the Indian ecosystem? And probably we can have few takeaways from that.
So there are 2 points I'd like to make on relevant office holders. So on the DRO point with the debt advisors, it's good, but the insolvency system here is, there's sort of like a posh end of town in the sense of, like, corporate law firms dealing with big reconstructions, and then debt advisors who work for charities generally, or sometimes local government, who are doing the kind of day-to-day work of helping people in the regions and so forth. And typically those debt advisors are not qualified insolvency practitioners. They're individuals who've done partial certification on their way perhaps to that status, or they've done some sort of training course within, for example, the Citizens Advice Bureau, things like that. But that's perhaps the way it has to be because of sheer numbers of use. So like we reflected earlier when we were looking at debt relief orders, and the idea that now they account for double the amount of bankruptcies. So in 2020 there were 12,625 bankruptcies and 20,321 debt relief orders, as compared with 78,478 individual voluntary arrangements. And that brings me on to my second point, which is this. So even with our insolvency practitioners, who are these office holders who have professional qualifications, so accountants, so the most highly qualified type of insolvency practitioner or specialist you can have, we have deep problems with those guys in terms of qualifications, in the sense of, even though they've got qualifications, we have really bad problems. And one of those problems is highlighted by those stats I've just mentioned. So remember, there's 12,000, just over 12,000 bankruptcies, just over 20,000 debt relief orders, and then nearly 80,000 individual voluntary arrangements. And basically those numbers of IVAs are driven by what's known pejoratively as IVA factories. So what this means is that an IP, so a highly qualified, lots of exams, etc. person, is advising debtors to take out an IVA, so a term of payments over time, instead of bankruptcy and instead of a DRO. And the reason for that is, and again, there was research done in 2007 which demonstrated this, and here we are in 2021 with the same problem, that basically those insolvency practitioners are acting in a self-interested way and recommending, even though it's not perhaps the best solution for that debtor, that IVA. And the reason for that is because they can front load their fees and take their fees at the beginning, the IP, and it doesn't matter if the IVA then fails because they've already got their fee. So of course the question is that the best thing for the debtor? Obviously the answer is no, because they've just gone through a failed IVA, wasted time in that when they could and should have perhaps done a debt relief order or even a bankruptcy if they owed that much. So what that demonstrates is that in English and Welsh law, even with the reforms to education requirements that were introduced in 1986 to try and professionalise insolvency practitioners, we still have deep problems with their professionalism that aren't being handled properly by the regulator, because obviously it's still happening 13 years after it was identified. So my thoughts on your document, where you've got on the last page at the top, just after footnote 13, you say a person in the UK can become a debt advisor by having relevant experience in the field or by pursuing a certificate course diploma, and then the question is whether or not you should have minimum qualifications that should be lowered. I'd say no, we need to appreciate that we've got a huge burden of lots of advice that needs to be given, so we need to have a balance between, on the one hand, getting that advice out there that's appropriate, but on the other hand, ensuring that we don't allow the kind of behaviours that even qualified people do, because it's problematic.
Professor John, one of the major reasons why we highlighted this point is because obviously when you have qualified people working on matters like these, where the fees is very low, the only way they'll try to earn a profit is by economies of scale, by achieving economies of scale. So you attract more and more people into this scheme so that you get a percentage of that fees. And Shailendra sir, the recent report of this committee mentions that the role of these insolvency advisors is being reduced to a great extent. So it's only till the application stage and not after that. So do you think people with such high qualifications are required for a job like this, or can IBBI come up with a certificate course or an examination that any postgraduate qualifies and clears, and then he can be an insolvency advisor?
Right. Yeah, of course, as a matter of principle, I drew the analogy. Now, whether someone is a poor patient or a rich patient, the doctor has to be fully qualified. That is what I said, because here ultimately someone has to judge that somebody has suffered a loss. Somebody is in a distress. That is a very acute kind of a situation, right? Like a doctor has to diagnose. Here also the resolution professional has to diagnose well that someone has really faced a distress, right? That is sometimes not that easy, right? So those whom you may say that they are less enough, let us relax this qualification, etc. But if you can bring in again some qualified people who are capable, so that is also fine. But they need to have this clear understanding and this kind of ability. As long as they have got, that should be fine. Okay, that's like for example, even in various court cases, it's not that all senior lawyers handle always, right? Junior lawyers also handle many of the cases, right? So that is what my take as I said this, right?
Renuka
Yeah,
ma'am,
John,
so the question,
just mention the data you shared some. Just can you highlight again the data that you shared for such cases? The data in UK.
Sorry. So the data on the statistics of I'll send that over the statistics on the amount of use. On that, your sort of doctor analogy, the medical analogy, I suppose what we see here with the IVA activity in terms of like if it was a doctor who was in charge, it would be, I suppose, a doctor who would be recommending plastic surgery for like new ears or something like that because the doctor was going to profit from the new ears, not because there was anything wrong with your ears. It's that kind of thing. And of course, I suppose ethically that's probably problematic even for a medical doctor as well. You know that, but good if your glasses keep falling off because you've got new ears to keep your glasses on. So
Okay.
it should. I don't know if you've seen it, but Professor Warren in America with she's now Senator Warren, Elizabeth Warren, and Teresa Sullivan as well, and Jay Westbrook. They published an interesting book called The Fragile Middle Class, where they were looking at American responses to bankruptcy, and they used a lot of medical analogies in that, which was good. Sort of interesting way of thinking about it. Yeah.
Okay.
so ma'am, Renuka ma'am, the question is then twofold. That first of all, the work that is being envisaged for these insolvency advisors, does it require such high qualification, especially since it's till the pre-application stage? And the point that Professor John highlighted, that this may give rise to some unwanted behavior by these professionals, where they try to achieve economies of scale by attracting more and more applications. What's your thought on it, ma'am?
So I think that, instead of the frame that I would use is not a high income patient versus a low income patient, but I would use the frame of a simple procedure versus a complex procedure. So to the extent that we agree that personal insolvency is quote unquote simpler than corporate insolvency in terms of understanding the budgets, understanding the assets, understanding the liabilities. There should be a distinction between those who do personal insolvency and those who do corporate insolvency, because the skill set is different and the complexity of the documents is different. Similarly, in the class of all the personal insolvency cases, again, people who it depends on how we envisage this fresh start process, right? Is this a quick process where there isn't much documentation and the default is that once you apply you will be given a fresh start, versus is it a process where you have to prove that you have actually absolutely no way to pay and you meet all criteria, and that process of proving that you meet the criteria is a cumbersome process. So I think that if we choose a more simple process, then it may make sense to reduce the qualifications of the RPs, and actually have a category or a cadre of people who are more in the line of counselors, credit counselors, who guide people to navigate through the fresh start process. Also, responding to the point that Professor Tribe had made about this, the IVA versus bankruptcy slash DRO choice. Again, it's really a matter of how you structure the system, because at least the way it's envisaged in India, for a large number of people, the pathways are very clear. Somebody with a certain kind of income slash assets, is only going to qualify for a fresh start. And hence, this, when you go to somebody and that somebody has to advise you on where to go, if that has been taken away and a fresh start is a very clean, clear, simple process, then perhaps you don't need RPs that are as qualified to actually, either do corporate insolvency or do the complicated IVA like processes in India. And hence a cadre of counselors is enough. So I would say it really depends on the complexity of the procedure that we envisage.
Yeah.
Absolutely. It was a very enriching discussion, and if it's fine, we'll take a couple of questions from our classmates. The first one being Shashwat, would you like to speak?
Yeah, good afternoon, everyone on the panel. I think it is good morning, sir or sir. What my question was, how should inheritance be dealt with if household or other assets will be transferred on a later date? So, if the family member of the person who is under bankruptcy, how should his inheritance will be dealt with? Because he will be receiving a certain amount of assets in inheritance. So what about that? How will fast track insolvency deal with that, or how should it deal with it?
Do you mean, so let's say they go into bankruptcy on the 1st of January 2020, and then on the 1st of July 2020 they get an inheritance whilst they're still in the bankruptcy process? Is that what you mean, that in that kind of sense? So
Even if they are in the bankruptcy process, or if the bankruptcy process has ended.
yeah, so that we not so much around inheritances, although what we might call after acquired property. So the idea of getting property, like you're suggesting, after the advent of the insolvency engagement. The main area that we have tensions, it isn't inheritance, but it's pensions. So the extent to which, for example, a bit like the house point earlier when we were discussing, what assets should be available. And of course, pensions is contentious in the same way that Professor Slindra earlier on was talking about. You still need to give people houses. You can't just chuck them out on the street. And indeed, both panelists said that. And what that means is, in the context of pensions, is obviously also when you're older, you still need to be looked after. So the burden would then fall on the state if it didn't, you didn't have your private pension. But of course, the pension can be taken as part of the assets in that statutory compact. So in the same sense, it would be the case that inheritance here would be potentially vulnerable in the same way because of after acquired property provisions. So I suppose my concluding thought on that would be, make sure that if a will has been drafted, that it leaves the asset value to somebody else who's friendly to you. I shouldn't advocate those creditor defrauding mechanisms, but you get the point. It's vulnerable, basically. So yeah, people would need to be careful. And by vulnerable, I mean vulnerable to creditor claims as part of your estate. That's in English law.
Okay, sir. Thank you, sir. And if any other panelists would like to give their views.
Yeah.
Yes, Nikhil, you may go ahead with your question.
So good afternoon to all the panelists here. I have a question to Tribe, sir. Sir, the debt to GDP ratio in India is very much low in comparison to UK, US, or if I talk about developing countries like China as well. So we have only almost 56%, and the other countries are having more than 100%. And we are trying to adapt kind of an FSP which is there in other countries. So when this would be adapted in India, when this would be adopted in India, the banks would be more cautious while giving the loans, and that would certainly harm this ratio as well, while the authorities are trying to increase it. So how can we maintain a balance in that? Because we need to increase credit so that there is more development in the country. So your take on this?
Yeah, I suppose there's 2 points. First, I agree with you totally that there are tensions and issues around transplanting one legal regime, DROs for example, into different jurisdictions that might have different different activity economically and socially. So yeah, totally. There's sort of those points to be cautious of. Uh, albeit sometimes it can still be positive. And then your point about not wanting to preclude credit extension, I always find that a kind of strange. I'm not saying you're strange. I'm saying the sort of the position of creditors not wanting to lend strange, because if India's 1.3 billion people, something like that, approximately, massive market for any business like Amazon or whatever. So with banks, the idea that banks wouldn't view India attractively as somewhere to come and try and do business is, in different ways, is, albeit small end and top end, etc., is querisome, because of course, I get your point about much lower rates of income, etc., but in developmental purposes that will change, won't it, over time, maybe. So the banks will want to be there, and anyway, banks shouldn't lend against empty vessels, should they, in the sense of when they make credit decisions and extend loans, etc., the people that they're lending to should be able to pay back. And if banks are foolhardy enough to make loans to people that can't, then the banks have to suck that up as part of their gearing, like you were talking about earlier, of interest rates, etc. So I don't have a fear that banks won't continue to engage in a given jurisdiction. I think they'll just alter their behaviour to make sure they've got a shoehorn in that jurisdiction. But don't forget, I'm a insolvency scholar, not an economist like Dr. Anuka, so she'll probably have a better response than me.
So I just want to make one point. I agree with you. However, I think that in India we have many supply side constraints or regulatory constraints in who can come in and what they can do and under what circumstances. So while in general I completely agree with your point that there is a huge market, not just for one kind of bank, but perhaps multiple kinds of lenders with multiple business models. But that is the reason that it has been slow to take off, is that we have been very conservative from a regulatory standpoint in who we allow, what we allow, and under what circumstances we allow. So the supply side response in India will always be muted until we change our regulatory perspective on the banking industry. And I can go on and on about my quibbles with the Reserve Bank of India on how they regulate the credit industry, but perhaps that's best left for another day. But that's why it becomes a little difficult. And these debates, because one side of the market is choked. And so the normal responses that you would see from creditors in other jurisdictions, you will not see here because they are not allowed to do certain things.
Is that a matter of time, though, in the sense of their sort of powerful lobbying activity? So do you get...
So banking is extremely government dominated. So we have a large public sector banking industry. And I think that that's a artifact of the nationalization of banks in the 60s, 70s, and I think that that's not changing anytime soon. And for whatever reason, whenever we see credit crises overseas because of subprime lending or whatever, unfortunately the lessons that we draw from there is to completely choke off the market here. Or even when we see microfinance crises that we have seen in other parts of India, the lesson that we draw is to make regulation extremely tight on, say, the prudential side, which makes capital very expensive. So I think that I'm straight, but this is there's a reason why the industry is like this, and that industry and the structure of the regulation and the industry as a consequence has consequences for how insolvency will play out. Or for what response you will see from creditors. And I think that that's something we need to keep in mind as we go, talking about the insolvency market in India.
Yeah, it sounds like a sensible policy to me to keep out the private sector credit in that sense as much as possible to forestall the kind of issues you've just highlighted.
I mean, as a result of that, we have the debt to GDP ratio that we have. We have huge financial constraints. So, of course, nobody is saying that, you allow everyone without any rules. But, our extreme policy of allowing very few people with very tight rules has also had its costs. It has led to a mushrooming of the informal sector, which is probably worse than having some NBFCs or fintech companies doing a lot more lending. So, there are difficult questions on how the structure of the market is and how it should get organized. And people in India have very different positions on this. And I think I am in the minority here. Who thinks that things should be more open and more players should be let in, and the RBI needs to relax a little on its prudential requirements. So I'm all for consumer protection requirements, but very often in India, we've solved our consumer protection problems by bringing in prudential requirements. So I think that's the nature of the market that does have implications for how the insolvency sector works or will work whenever it does.
Yeah. I think just briefly that the idea of sort of governmental input then does ring a little bit of a bell here with the way in which the tax authorities perform. So that point we made earlier about tax creditors in bankruptcy being overzealous, and then if you've got your creditors then are essentially state run, then you'd hope that they temper their behaviour, wouldn't you? But that's our tax authorities don't temper their behavior.
No, but the state-led banks then are probably not lending to this sector at all. It's only through this SHG model, which is smaller, I think. I mean, the real big sector is the microfinance sector that will come into the fresh start process, right? So, of course, banks will make loans they do a lot of personal loans. Personal loans have been rising in the last 10 years or so. But the fresh start provisions or the market for fresh start specifically will be microfinance loans. And under agri, there is a huge subsidized agricultural credit in India, and that has its own set of problems on who you can lend to, who you can't lend to, under what rates, under what conditions. So it's not a free-flowing market in the way you would think of other jurisdictions. And hence, some of the things that we think about in terms of a market response or a creditor's response will not take place here.
Yeah. I bet there were whole arms of banks who are in strategy targeting India, thinking about, right, how can we...
They wouldn't licenses. I mean, in the last 10 years, we have given out 3 licenses, or maybe, we don't want entry in banking. Simple.
Yeah. Much to the disappointment of many banks.
So do we have any other questions from the participants? Anybody? Okay, I think there are no other questions. In case there are, you can forward it to us and we'll make sure that it gets addressed as soon as possible. Ekta, over to you.
Thank you so much, Sharendra sir, Professor Dr. John Shrive, Renuka ma'am. We remain grateful for your participation, and we have had many takeaways from this roundtable conference, and I'm certain that I think the next batch we're going to have once these we are notified provisions, there'll be a lot more deliberation and food for thought to be taken away. And special thanks to Professor John Shrive for highlighting the UK model and giving us good takeaways. Sharendra sir and Renuka ma'am, the challenges and the policy implementation which needs to be carried forward. And thank you all.
Thank you very much.
It was a good, the format was good. I would say the format was good. The note was also good for in terms of actually what is expected. So I therefore congratulate on this. Maybe you could have allowed questions at the end of each round, at least even 1 or 2 questions from the participants. At the end of each round, if you would have allowed, that would have made the discussion even more richer. But overall, it was good. Congrats and thank you very much.
Thank you.
Noted, sir. We definitely do it next time. Thank you.
Bye.
Neetiman, over.
Yeah. Thanks very much.
Yeah.
Cheers.
Thank you, Professor Shailendra
Thank you.
and Dr. Venuka. I think you both have been very benevolent with your time. And I think the way you have added to the discussion is really remarkable. And a special thanks to Professor Try. I
No,
reached out to
thanks
you
for
at
the
such a
invite.
short notice.
No, don't
I
worry.
mean, can't thank you enough. I reached out to you such a short notice, and you accommodated our request. And thank you so much. And we will take care of the comments that we have received from the panelists and improvise the next session. Thank you so much.
Yeah, no, thanks very much for the invite. I really enjoyed it, and it's good to make some new friends in India as well on to discuss these issues. So that's cool. Thanks very much.
Thanks a lot. Thank you.
Thank you. And Ekta, thank you. Rustam, thanks a lot. And to all our dear students, thank you.
Thank you, everybody.
Thank you.
Now I need to try and work out how to log out. Say,
You can just close the tab.
oh,
Well,
okay.
we don't,
Well,
see, honestly, Professor Try, we don't want you to leave. And that's why we made the system so
well,
complicated.
you guys can now have lunch and I can now have breakfast. That's the.
Sorry, apologies
No,
for that.
don't worry.
So here, so if you go to the left of the screen
Oh,
where
yeah.
you will see a small recording button
Oh yeah.
and you press there.
Okay.